the alleged violation of Garrett rights and the failure of the trial court to grant my suppression motion. I think this may be an issue of first impression in this state, at least substantively, and wanted to give the court some background. On the morning of June 18th, 2020, when Tennessee Highway Patrolman Keith Garrett was lured to the Nashville THP headquarters, the headquarters of his employer, I submit under false pretenses. I think he walked into one of the most inherently coercive employment termination, criminal investigation environments that anyone could imagine. I would submit to the court that it was an environment that was purposefully created by THP and the Federal Bureau of Investigation with two goals in mind that morning. And those goals were to fire him, ultimately fire him from the Tennessee Highway Patrol, and basically scoop him up on a criminal charge. It would have been a win-win, and it ultimately was a win-win for both of those agencies, the Highway Patrol and the Federal Bureau of Investigation. I also respectfully submit to this panel that anyone in Keith Garrett's shoes that morning would have concluded that if he did not cooperate and answer the questions of the FBI, who were not coincidentally in an adjacent room there at the THP headquarters, would be going to be losing their job as a highway patrolman. I think that the determination of this issue, this Garrett issue, really deserves some discussion of the circumstances that Keith Garrett was confronted with that morning. And if you'd indulge me, I'd like to talk a little bit about those circumstances and the timing of things that he was confronted with that morning. He was told he was being assigned to monitor ongoing protests just right up the street here that were in the wake of the George Floyd death that were occurring and expected to occur that day outside the Capitol building. He reported for work that morning at 6 a.m. He reported to, I think, the War Memorial Building. He sat through the required debriefing, and as he's leaving to go take his position at the state capitol, a Lieutenant Thompson with the Highway Patrol orders him to report to the Nashville THP headquarters patrol lot, which was sort of an odd assignment. Mr. Garrett, of course, didn't question the order of his superior. He traveled directly to the patrol lot and found himself standing in a parking lot looking at cars for about an hour. He then receives a phone call from another superior, Lieutenant Leverett, calls him and orders him to report to the THP administrative building, which is on that same campus. It's a building known as the Butler Building. And that is a secure building. You can't get into the Butler Building without a secure key card access. There's also, to digress just a moment, another dynamic going on here. Prior to June of 2020, Mr. Garrett had filed an EEO complaint against the Highway Patrol. He had been working there for 23 years, wondering why he had been passed over for a promotional test that he thought he was had reached a point where he could take that position. But back to the Butler Building. When he arrives at the Butler Building, he's met by Major Roy Brown with the THP at that secure door. He's escorted into a conference room where THP Captain Chris Ray is waiting. As soon as he goes into that room, Captain Ray hands him a discretionary leave notice, takes his credentials, his car keys, and his firearm. Captain Ray then tells him, "You're on discretionary leave pending internal investigation." And I think the timing of this is significant too. Captain Ray's statement was made at, according to the evidentiary hearing, made at 7:58 a.m. Within a minute at 7:59 a.m., Mr. Garrett is delivered into the hands of the FBI, who are assembled in an adjacent Highway Patrol conference room. He then proceeds to submit to two interviews, one 80 minutes in length and the other 40 minutes in length. During those interviews, the FBI tells him, "You are the focus of this investigation, and lying to a federal agent is a crime." The admissions made by Keith Garrett over the court...
He's also given Miranda warnings, though, is he not?
He is given his Miranda warnings, yes, sir. The admissions made by Keith Garrett over those two statements, over that 120 minutes it was truncated, I submit were coerced. In that moment when he's taken into custody by the FBI, and the reason I say custody, they felt constrained to read him his Miranda warnings, as Judge Greenholz just pointed out. Obviously, that's the equivalent of a custodial situation. So he's in a custodial situation when he's still in his employer's main office in Nashville. And I suggest that the proof shows at that moment, and I think it's reasonable to find this, that Mr. Garrett was forced to choose. If he doesn't talk to the FBI, with his bosses still in the next room, that discretionary leave that he had been served with at 7:58 a.m. when he crossed the threshold into that room is going to turn into the end of his 23-year career with the Highway Patrol.
Is there objective evidence of that? I understand, I think, the argument that that's a subjective concern. Where's the objective evidence of that, though? Because the FBI, at least from my review of the record, isn't threatening him with employment. I think that's what he's thinking is occurring, but the FBI itself is not doing that. They're interviewing him with respect to a crime that's been committed. So what is it about the circumstances objectively that the FBI itself is either going to communicate the information to the Highway Patrol, is working in connection with the Highway Patrol in part of its federal investigation, or that the FBI itself is actually threatening the defendant with his job? Where's that objective evidence?
I think the objective evidence is the coercive atmosphere that was well thought out, well orchestrated to get Keith Garrett through that door, to in effect start the process of firing him, and then 1 minute later say the FBI is here to talk to you.
Okay, but the FBI is not involved in the employment law context here, or is it?
I think they are, and the reason why I think they are is a conscious decision was made to join these two events under the same roof at the THP. So he sort of walks in, he's off balance, he's told you're being placed on administrative leave, and a minute later he's in front of the FBI. I think a reasonable person in Mr. Garrett's shoes would have felt like, well, these two agencies are working together, and I certainly don't want to lose my job. I've got, respectfully, 1 foot on the banana peel since I've been given this notice of discretionary leave, and unless I just walk through this door and talk to these people, I'm going to lose my job.
Okay. Did the FBI communicate the substance of its interviews, either interview, with the THP?
Judge, I don't know the answer to that.
That seems to be important, right? Because if we're suggesting the FBI and the THP are working together effectively to convict this man of a crime and to get his discharge from the Highway Patrol, it would matter, wouldn't it, in the analysis that, hey, we've interviewed him twice, THP, this is what we learned in the investigation, so when you talk with him tomorrow, be aware of what he told us. And if we don't have any evidence of that, it seems to be removed from the employment context.
I think that the thing to keep in mind is the FBI task force that was at work in this case contained a Tennessee Highway Patrolman by the name of Al Seitner. So there is a direct link between the investigation that was being conducted by THP, that was employment, and Mr. Seitner is the affiant on the arrest warrants and the search warrants that were issued in this case as well. So it's respectfully sort of an incestuous relationship.
Is there any indication at all that the prosecution of the federal crime depended in the least upon his continued employment status?
Well, ultimately it was not a federal crime. They thought it could be a federal crime.
But it's an investigation of a federal crime is
Right.
what I'm saying. So, I mean, was there any indication the FBI had the smallest interest in his continued employment status one way or the other?
Judge, I think that the THP should have been aware that creating this situation would have raised an issue that I'm bringing to the court today. If they didn't want to couple these things, if they didn't want to get the pressure that was being exerted by the FBI, then they should have done these things separately. He could have been told that he had to give up his firearm and that he was being placed on administrative leave, and he could have gone home, and then the FBI could have approached him individually and conducted their completely separate investigation. But this is something that was planned by these two agencies, and I don't think it's a stretch to believe that they thought that they could get the maximum coercive effect by knocking his legs out first with the employment issue, and then literally 1 minute later escort him into the room with the FBI. So I think the court can find and infer that these agencies were working together.
Okay. Is it your view that the FBI itself then, because it's conducting the interview on the campus of the Highway Patrol in a conference room with the Highway Patrol shortly, I mean, within minutes of the defendant having his badge removed, having his weapon removed, that the FBI had the obligation to administer a Garrett rights warning?
No, I don't believe the FBI had the obligation to do that at all.
Okay, so when would the warning have come then? Would the warning have come, let's say when maybe it was the captain that stripped him of his badge and his weapon, would the captain at that point have said, hey, the FBI over here is waiting on you, let me go ahead and administer to you a Garrett rights warning, even though we're not questioning you and even though your employment's not on the line, and we'll talk about all that tomorrow?
Judge, I think it's 7:58 when he walked into that room, and they put him on discretionary leave, knowing that the FBI is right in the next room, that the Garrett rights should have been advised to Mr. Garrett. It's something that they had the form, and they made a conscious decision not to give him his Garrett warning.
Okay, so the warning should have come at the time that the badge and the gun are taken and he's escorted into the FBI conference room.
With all the planning that went into this, you would think that these sophisticated agents and these Highway Patrol executives, somebody around the table would have said, well, what about his Garrett warning?
Well, they might have if they anticipated the FBI giving them the results of the interview or information from the interview. But if everyone in the room understood that's a federal investigation, they're not going to make privy to us what he has said in the course of their federal investigation. At that point, I can't imagine necessarily that Garrett warnings would have been.
Judge, remember, Officer Seitner was on the FBI task force. He was one of the agents working on this, what they thought was a child pornography investigation that turned out to be unlawful photography. So they knew that they had a foot in both camps.
Okay, so do we know that the FBI interviewers shared the contents of the interview with Officer Seitner? Do we know that?
I would think so. He was the case agent on the case, so he is immersed in this situation. I can't imagine that they would even attempt to put up a Chinese wall that would have kept the lead case agent from knowing the results of those recordings.
Was the FBI interview mentioned the next day when the Highway Patrol interviewed him?
I don't know the answer to that, Judge. That was not anything that ever came out at any evidentiary hearing, but this is a situation that was consciously created and orchestrated by these two agencies, and I think it's very significant to this court's analysis the role of Officer Seitner.
Was Seitner in the room with the FBI agents when this interview took place?
No, Your Honor. He was up in Macon County where they were serving a search warrant at Mr. Garrett's home. But I'm sure they were in touch with him. I thought it was also significant that this is happening so fast. Mr. Garrett's not a lawyer, and there are no FOP advisors anywhere in sight that can talk to him or offer him any advice, and he's being shuttled from one room to the other. And I think it's a violation of his Garrity rights, and that the trial court should have suppressed the statements. The admissions that he made during the course of those two statements were probably the cornerstone of the state's case against Mr. Garrett. So I think the situation that was created for Mr. Garrett that day is really the antithesis of a free choice to speak or to remain silent. I think anybody objectively would have believed that if he didn't cooperate with what was going on that day, that he was going to be relieved of his duty. I have, I think, 1 minute. Can I reserve that 1 minute?
Sure.
Can I take part of your 1 minute?
Go ahead.
Yeah.
Help me with this, as I was looking for authority that would suggest that Garrity rights must be administered in this kind of context. I didn't find any, even in Tennessee, but I'm talking even more nationally, where the issues has been discussed in other cases. What authority do you rely upon that the Garrity warnings must have been given before he went into the FBI interview room, or that his statements then therefore should have been excluded? Can you give me a case or two?
Judge, there was a case that I cited, I think the case out of the Southern District of Florida.
Okay.
It was a district court case. It seemed to be in that case that there were some contemporaneous Garrity warnings that were being given to those police officers. And that was, and I'm going from recollection here, but I think that was sort of a quasi, those officers were in some trouble.
Okay.
That I think they could have been at risk for criminal prosecution in addition to losing their jobs.
Okay.
And
so they were administered in that case, but does that case say that the Garrity rights administration should have or must have occurred here?
I don't have a case that says that, but if his employer is acting in good faith with the employee, and they've set in motion this scenario where they want to, on the one hand, let him know that, hey, you are really on thin ice with your employment. This is the first formal step in you losing your job. And then remarkably, 60 seconds later, he's introduced to the FBI. I think that he deserves some sort of warning about his Garrity rights under that scenario.
Okay, thank you.
Thank you, sir. For the state of Tennessee, Ms. Weldon.
Good morning, and may it please the court. Caroline Weldon on behalf of the state. I would agree with the chronology of events that Mr. Schreins just described, but I would draw the court's attention to some of the key context that's encompassing those events that took place that morning. Importantly, the defendant was then employed as a trooper for the Tennessee Highway Patrol, meaning that he was armed, that he had a service vehicle, and that investigating him for any crime, but especially for the crimes which he was suspected of in this case, would have made for an explosive arrest, a dangerous arrest. And there was testimony about that at the suppression hearing, where witnesses offered that in other situations when members of law enforcement had been arrested for charges of child pornography or the like, that agents had been killed in the process, given the level of embarrassment involved with those sorts of charges. And so I think that that is a key aspect as to why this investigation was initiated in this way. It was for the safety of all of the people involved, including the defendant, including his family. And so I think that was a key piece of this puzzle that I don't believe was delved into as much earlier. Turning now to the...
How does that relate to possible coercion, though?
Well, I think the suggestion that this was devised in a way to force him to speak to law enforcement. I don't think that that's reflected in the record. I think that he was brought to headquarters in this manner for the safety concerns and not to force him to speak with the FBI that morning.
Okay. I mean, your friend suggests, though, that irrespective of maybe the intent, maybe objectively it was coercive, because he's ordered there by a superior. He shows up, he's immediately placed on administrative leave, his badge is taken, his weapon is taken, service weapon is taken, and then he's escorted instantly into a conference room with the FBI. The FBI administers Miranda warnings, but I think the argument on the other side is that both objectively and subjectively, Mr. Garrett feels that he's compelled to speak. So I understand the intent maybe behind bringing him down there, but that doesn't really necessarily speak to the objective coercion that your friend is positing.
I don't think that it was objectively reasonable for him to think that his failure to speak to the FBI agents in that scenario is borne out in the record, because he was not employed by the FBI, and he was only interviewed by a member of the FBI and a detective from Metro Nashville Police Department. So there was no one from his employer, no supervisor, Agent Seidner. None of these people were a part of that conversation.
Let me stop you for a second, because this has been an issue in other cases where when you have this task force and you have a THP member on the task force, courts have looked at this as being a joint organization then. And the fact that, and this is what I'm asking you, does that change that? I mean, understand if it was just the FBI took him out and talked to him, then maybe that would be a separate thing. It wouldn't be involving his employer, and therefore it wouldn't be maybe a Garrett issue. But if the FBI and the THP are on a task force together, investigating, child pornography, whatever it is, and this arises, and they're part of the task force, doesn't that kind of meld them into one group?
I can appreciate the concern that if the record supported that had happened, that would be something for this court to consider. I think generally in law enforcement, collaborative efforts are not uncommon, and members of law enforcement wear different hats at different points throughout their day, perhaps. There was testimony about here what this task force looked like and what the Tennessee Highway Patrol's part in that task force was. And the testimony was basically that the Tennessee Highway Patrol would attend meetings when they were scheduled. So it wasn't as though the Tennessee Highway Patrol was investigating the defendant for this crime, or that they were a part of the investigation. There's nothing in the record to suggest that they received the information that was relayed by the defendant during these interviews. So that's just simply not in the record. And so again,
If your friend says this, and I just want to hear the response to it. Your friend says this: if it were not intended to be a coercive environment, the interview would not have occurred in the THP campus, would not have occurred shortly after he's being told, you're on administrative leave, let me have your service weapon, let me have your badge. That, instead, if it were not intended to be coercive, that the FBI and the task force would have interviewed him somewhere else and at another time, separate and apart from the employment concerns. But because they are so linked together, necessarily there is a connection there. What's the state's best response?
I think that, of course, as anyone who is a member of law enforcement and is placed on some sort of leave, he would understand that he was in trouble and that he had been caught. This was the first time that he realized that what he had been doing had been discovered. So yes, was it subjectively reasonable that he thought that? Sure. But I don't think that the conversations that...
It's a different ballgame if they show up to his house a week later. So the FBI comes knocking on his door. Mr. Garrett, we'd like to speak with you. May we come in? completely unconnected with his employment, and then we don't even have the issue. But what we have here is he's being summoned to THP's offices. He's being stripped of his employment. He's being stripped of continued active duty with the badge, and then, as your friend says, hustled into the conference room next door where the FBI is waiting for him.
At no point during the sequence of events was he told that if he did not cooperate with the FBI, that he was at risk of losing his position with THB. The FBI never said that.
Does Garrity require warnings? And this is something that I'm a little confused about, admittedly. I know that there is even the case that Mr. Strands indicates refers to it as Garrity immunity. But is there a requirement that warnings be given, or is it just something that arises by matter of law when you have objective and subjective coercion?
Within THP policy, yes, you are required to read Garrity warnings.
Okay, by virtue of the policy. Okay.
Yes, and it's been interpreted, well, when courts look to see if Garrity has been violated, those are the considerations that courts have looked at. And as Mr. Strands addressed, this is the first time that this court has really been faced with this issue. I couldn't find any other case law in Tennessee that really got in to what Garrity means in this context. I would like to point out that that there was no, when the defendant had his initial, when he was relieved of his duties before he spoke with the FBI, it was not an interview, it was not a conversation. There was no reason and no point to issue Garrity warnings because of the nature of that proceeding. The Captain Ray did not have to give those at that juncture because they were not interviewing him about any wrongdoing. So there was at no point during the sequence of events should Garrity warnings have been issued.
What would have happened if Garrity warnings had been administered? Let's say that the captain administers Garrity warnings before he goes in to talk with the FBI. What's the practical effect of that?
Well, I think that raises an interesting issue as to whether the Garrity warnings would then travel with the defendant throughout different conversations with different members of law enforcement.
Well, the Garrity warnings, and help me with this. I mean, admittedly, I'm new to this, and I'll confess the neophyte nature of these questions. The Garrity warnings, as I understand them, say, okay, you can talk with us, you cannot talk with us, but the information that you give us are not going to be used in a criminal prosecution. But we can fire you if we think that that's necessary. So if that kind of rudimentary understanding of Garrity is correct, and he is actually told that the statements won't be used against him, can the statements later be used against him?
Well,
So what I'm saying is, if he had been given Garrity rights, are the statements automatically immune?
Well, I don't think that they would be immune. I think that it would be about the risk of the loss of the job.
Okay. All right. I'm not making my question clear, but and I apologize for that, if you'll continue.
I'm trying to see if I can point to a case that would help make this a little bit more clear, because there are plenty of situations in which members of law enforcement or the Postal Service are accused of wrongdoing in the nature of their jobs, and then they're brought into a conference room and asked about that, and then warnings are given, and they're told that we can't force you to talk at the risk of losing your job. So I think he was never a member of the FBI. The FBI never threatened him with loss of his job. They had no control over the loss of his job. It was two separate entities at the headquarters, and I reject that it was a deliberately coercive environment for the purpose of extracting this information from the defendant. And to that point, the trial court considered all that the defendant said when he spoke to the FBI the first time. And during that first conversation, he denies everything. So he understood that well, let me rephrase that. He chose to lie. So he wasn't cooperating with an investigation because he was concerned about the risk of the loss of his job. He was thwarting it by lying and denying that he knew what they were talking about.
Sure, and he invokes his right to remain silent in the second interview, right?
No, he
No?
confesses in the second.
Second interview, okay.
Yes.
All right. So maybe this is what I keep coming back to, and once again, I'll confess my ignorance on YouTube before the entire world, but what seems to me kind of a miss is that the way the argument's constructed is that it's a win-win for the defendant. And I'm wondering how far that goes, and I'd like your help understanding where the logic breaks down. On the one hand, if Garrity warnings are not administered, then there's a coercive environment, and the statements are out because they're coercive. On the other hand, if Garrity warnings are administered, and I'm specifically told that that the statements can't be used in a criminal prosecution, the statements are out. And it seems like there's not a situation where the statements are ever in, and I'm trying to figure out why that is. Where am I misunderstanding the nature of the arguments here?
Well, again, Your Honor, I think that it's not that the Garrity statements are out for a criminal prosecution. The statements, they cannot say that unless you talk to us, we're going to fire you. I think that's the crux of Garrity as I understand it.
Well, I just know that back in my prosecutor days, when we were investigating, when we had an officer coming up, if a Garrity statement was there, we couldn't even look at it. We were not even allowed to consider it in criminal prosecution. So, you know, again, I'm no expert on Garrity. I just know that it was a pretty big deal. If a statement was taken under Garrity, we weren't even allowed to look at it. There couldn't even be an argument that we use part of it as part of our prosecution. It had to be completely ignored. So, I mean, that was my recollection.
Right, and that's went back to my questions, back to your friend, was what information was shared, how was it shared? And then what he proffered in response to those questions was, a member of the THP is on this task force. And so it's going to be reasonable to think that all the information gained in the FBI interview is going to be used by, or at least made known to, the Highway Patrol. What's the response to that?
The record simply doesn't reflect that happened.
Does it reflect that THP is on the task force?
Yes, it does.
Okay, so it doesn't appear to be the wall that Judge Campbell's describing here. Is that right? Is that fair?
Well, there's no record either way. There's no record that there is a wall or that there isn't. It's simply not a part of the record. So I don't have a better answer as to that. It's just, it wasn't discussed at the hearing or at trial. But setting Garrity just to the side for just a moment, the defendant admitted to filming and photographing his stepdaughter at trial, and his face is captured in one of the recordings by way of the reflection of a mirror in the bathroom. So this isn't really, I understand the court's concern about how this information is introduced at trial, but even if this court were to think or to find that it shouldn't have been heard, it's really not, there was plenty of other evidence that the jury heard at trial, and the defendant does not dispute that he made the recordings and captured the images, and he testified to that at trial.
So is the state making a harmless error argument here?
I'm offering that as a fallback argument, Your Honor. I think that it was not objectively reasonable for him to think that any decision not to cooperate with the FBI that morning would have resulted in a negative effect at THP because of the difference in the entities, despite their collaboration on a task force.
And didn't TBI in their policy warning say that if you exercise your Fifth Amendment right, you wouldn't be fired?
That's correct. And this was not someone who was new to the THP or law enforcement in general. He was a seasoned trooper who had been a part of THP for over 20 years. He was aware of the policies. He was required to be aware of the policies.
We generally don't consider those kinds of factors in a Miranda analysis. I'm curious why we're considering them here. So we generally wouldn't come in and say, well, we know Miranda wasn't given, and it should have been because the suspect was subject to custodial interrogation. But you know, he'd been around a while. He knew about the Miranda warnings. He's seen them on TV. We generally don't engage in that kind of analysis with respect to Miranda, so why are we doing that with Garrett?
That's true. I think that because Garrity is a special protection afforded people in this particular group. And so the defendant, in my view, was better equipped than anyone to understand that he could remain silent if he chose. And not only did he choose not to remain silent after he was given the Miranda warnings, he chose to lie, and he chose to deny that he had done what the agents at his house were viewing in his attic. So he understood that and still chose to lie before he eventually admitted it during the second conversation. And I hope I've answered all of your questions. And if the court has no further questions about any of the other issues raised, I would rely on my brief as to those. And I'd ask this court to affirm. Thank you.
Thank you, ma'am. Mr. Stryance, in rebuttal.
1 minute. I want to address something that Judge Campbell brought out, the role of Al Seitner, the THP. He was the lead case agent on this criminal investigation. You'll see in the technical record, the case began with a general sessions complaint and warrant. He is the affiant on that warrant. He identifies himself on the warrant as Trooper Al Seitner and gives a THP address in Cookeville, Tennessee. So it's not some oblique role that THP has in this case. They're not only his tormentor for employment, they're his tormentor for the actual prosecution of this case. This whole case began with an affidavit of complaint that he swore to, which I claim is defective in my brief. And also, I don't know why the THP would advise somebody of their Garrity rights on the day after a event like this had occurred. It would have been helpful to anyone to hear it read to them before they walked in to talk to the FBI that I'm reading from Trial Exhibit 2. You are entitled to all the rights and privileges guaranteed by the laws and the Constitution of this state and the Constitution of the United States. And I'm emphasizing here, including the right not to be compelled to incriminate yourself. So I think that there is something that is just screams out to me of this coercion and collusion between these two agencies. And it just seems very plain to me that this was orchestrated to get the result that they ultimately got. And I would ask the court to reverse this conviction.
Okay. Thank you, Mr. Stryance. Thank you, General. Good arguments, good briefs in both sides here. This is a unique issue that we don't see every day. So thank you both, and we will issue an opinion shortly. Judge Greenholz, Judge Greenholz, Judge Campbell, any comments before we